The judgment is a decision can be 98. 98.5 is this. I'm just challenging which document, where is that? Yeah, got it. Page 55. This has only come in 2022. This document has only come and existed in 2022. Huh? I'm not concerned with that. The first is, have you mentioned it to anybody that this is the amount which will be charged? Huh? 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 Where is it? Page? Yes, where?
Total charges, should be funding the ground rent.
Merely mentioning out there without filling up anything, would it be mentioning that you will be entitled to?
Because at that point of time, it was ground rent.
So that is why, when did you inform them about the ground rent? Where is it mentioned that you will be entitled, you will impose upon them the ground rent?
So that's the release circular.
So what? Whether that railway circular will be applicable to you? The Railway Act is applicable only, it has been mentioned out here, if you see page 39, the inland way bill is issued subject to the conditions and liability as specified in the Railway Act. Nothing more than that. Then how can you include something more than that which is not there?
Ground rent has been defined in the IRDA amendment. And for that,
Don't come up with this probably business.
otherwise, that ground rent, the function of the ground rent law is the provision is there in the something when the books are not being taken by the outside law.
What are the rules for this overhauling charges which is there? This is only a guideline at page 55. Railway Board Circular. This has been done under what provision?
There are some notified commodities document. Those are the tariff.
No, this is done under what provision? This document, which is at page 55 of the new REIT. What is the provision, under what authority this has been done? Of fixing that in misdeclaration is detected in any container, haulage charges on the entire act shall be levied at 4 times of the highest container rate. This will be in addition to the haulage charges otherwise leviable on that rack.
These are policies of the government.
Huh?
These are policies of the
Understood. How are you applying it to yourself? This document, how are you applying to you? Now, have you paid this amount to the railways? You sure?
How much it costs by
No. Have you paid this amount to the railways?
You can collect from the consignor and then pay, subject to collect.
No. Are you saying that you have paid? No. Madam, the thing is like this. The inland, the inland inward bill or whatever may be, only says that the Railway Act shall be applicable. Fantastic. So they will be applicable only in respect of any penalty or whatever may be, whatever amount of that. Now the question out here is, can we apply these things out there?
We are following.
No, you are following it very good. You may follow many things. But I'm asking you, can you do that? Have you paid that? No, every time you come up with an instruction. No, this is a question which needs to be, because there is a challenge to this document. If there is a challenge to the document, you must be aware of this. Are you protecting this document? So you are not protecting this document. But in pursuance to this document, have you paid the amount of railways, taking into more particularly in view of this particular document which has been brought into light on the last occasion by Madam, wherein it has been stated out there in one IEM, where is that? This one, the Ministry of Railways 1992 edition, wherein it says the container service. ISO Container Corporation of India, a government of India undertaking under the Ministry of Railways have taken over the management and operation of ISO container services, including terminal activities at the inland container depot, earlier owned and managed by Indian Railways. The ISO containers are marine containers of standard dimensions, generally of 2 sizes and so on. These containers carry import and export oil. So, Madam, how does ISO containers have anything to do with it?
They even ship outside India, the same country.
No, do they? No, they are only for import and export.
No, also for Indian carriage transfer.
As authorized government to issue Concor invoice in lieu of railway receipt and to quote and collect all charges directly from the customer. Concor will separately remit railway freight at the rate fixed by the railway board to the concerned zonal railways periodically, for which detailed procedure instructions have been separately issued. Action to be taken for processing of invoices, inland bills in the data processing center of the railways and checks to be exercised by the tariff have also been laid down in detail. In the next few years, yes. But 1476, which we have relied, that is only for ISO are marine containers of standard dimensions, generally of 2 sizes, 20 feet, equivalent unit TU and 40 IT feet, equivalent IU. These containers carry import and export cargo between the ports and inland locations. No, between the ports and inland. So how do you bring this one?
No, they also come to Pandu. They come via Pandu.
Understood, but for import and export.
This is how it's done. For this, they handle the inlet, domestic.
So they brought it from Amingaon to your place.
So from there, after the stockyard is in Amingaon, not in the rail. It's in the stockyard also. I don't know whether lots of us while going to the airport, while going actually on the right, there is lot of this containers lined up. That's the Amingaon port. I had the fortune to visit that Amingaon port once because someone was working there. So that's how it handles the
The last, the transport of domestic cargo in these containers is also undertaken by Concor.
Yes.
This was issued in the year 1992. Now, this document of 2006, which you have given, That has been modified later on of 8/11/2006.
It's a figure.
Yeah. To all commercial managers, all India Railway. 8/11/2006. This is the document you gave on the last occasion. Huh?
Yes, that is also.
Is it still holding the field?
And 95, except for the 95. That is still holding the field. At least I checked all over. It has not changed over.
Because here B says, if in a consignment of packages chargeable at different rates,
Yes.
a group of packages chargeable at a particular rate is improperly described,
Yes.
and thereby a lower rate obtained, the charges at 4 times the applicable freight referred to in subclause A above shall apply only to the group of packages in the consignment improperly described and not to the entire consignment. These penal charges will be in addition to so and so.
But if this is the case, I have no.
So that is why I'm saying whether this still holds the field.
This I found, and I checked the name. That's all you can do. Also, it has not been superseded.
Let's see this can't be this is a rule.
Yes.
Let us see the rule of this Assam. This is the railway. What is this rules? Goods tariff rules. No, it's okay. There's some here. 126. This goods tariff cannot override this circular. These circulars cannot override. Penalty for false declaration. If on arrival it is found that the goods have been improperly described and that a lower rate than is applicable has been obtained, charges that double the class 1 rate will be levied by the goods owner. If in a consignment, charges that differ a group of the charges that particularly improper and low standard shall apply only to the group of persons. So 1B, 126, 1B.
Yeah.
So in view of this, unless these goods tariff, this is a rule.
Yes, sir.
So these rules can't go contrary, or these notification cannot go contrary to the rules.
Everywhere, even in the ad, everywhere.
Have you taken this down in your petition? Have you taken this down? I don't think so. I don't think so. That is.
A lot of research, then they came out with this. I have said it's violation of
No, you said something else out here. Your primary contention is this.
No, I said it's violation of this and
Understood, but then also I think you need to bring this somehow, some manner, don't you think? Otherwise, they will, as you know, Mr. Sharma, he will come up with another thing. You have to bind him. I think better off, because in addition to this, you can take this particular ground, because if this is the, if this particular document makes it very clear that it can be only chargeable for that, then how, if it is done, how haulage charges, which is a charge which is being taken, could have been taken for everything? Because there are two things. Under what they are also doing this under haulage charges is done under the what goods tariff. Under what provision is this go? Haulage charge is done. Has the affidavit been filed in a rate circular? If 5 cases of misdeclaration are detected for particular CTO, suitable action may be initiated under article of the concession agreement.
One of that circular.
Hmm?
One of that circular. Superstition of great circular number so and so. It has been decided that police charges from movement of 945 commodity mainly cement, aluminium, materials.
Now, this is the supersession of a rate circular. But if this is a case of misdeclaration, the case of misdeclaration, then you have these general rules. The general rules, these are the general rules. So,
The thing it has been said here also, this circular is as a guideline also, and things that is classified in the books there, 45 point number 1 of unit 2, that is being followed, and this
of
supplements as a guideline also. Guideline
but this is the general classification of contained in has the authority of the central government. Now, the general classification of goods. Now, this particular document, Indian Railways Conference Association Goods Tariff number 41, Part 1, Volume 1, number 40, not printed, containing general rules for acceptance, carriage, and delivery of goods. Now, if in that thing, in those rules, it has been mentioned that you can hold only as regards the misdeclaration which has happened, only as regards those consignments, not beyond that. Then in that case, can by these guidelines overstep upon these rules. Madam, I think you bring this on affidavit, a short affidavit. Just bring this point out there on an affidavit, bringing on record this one and that one. This 2016 6 as well as this. So that if that is being brought in, and more particularly Rule 126. Now, can this override these? Can these guidelines override, or can the railway board override these rules? Because these rules has the stamp of authority from the central government. But the railway board is not the central. It stands in a lower pedestal. So I think better you do it. How much time? Yes, you do it. Because then if that is done, I'll fix it up to 2 weeks. You file it within 1 week, you will reply. Railway is not there. Railway is not bothered. We put it non-appears for the railways there. When the matter is called, in spite of various waiting for 15 minutes, in spite of waiting for 45 minutes. Huh? No. Understood, but the railways have also, railways have issues. First of all, this court has the difficulty in accepting that on the basis of the inward bill, the conqueror can impose anything unless the conqueror says that they have paid anything to the railways on the basis. If they have not paid or they are not bound by that, you can't impose upon the consignor. And if the consignor can't be bound, you can't impose upon the petition. So that is it. So this is in WBC number 1974. Yeah, please. I'm just passing an order for the purpose of filing an additional affidavit. We'll fix it on a particular date on 5th of October. Well, hearing the matter, Mrs. M. Hazarika, the learned senior counsel, has drawn the attention of this court to Rule 126 of the General Rules for Acceptance, Carriage, and Delivery of Goods, pertaining to goods tariff number 41, part 1, bracket volume 1, as well as a communication issued by the Railway Board to the Chief Commercial Managers on the basis of Rule 126, dated 8/11/2006. From a perusal of Rule 126, 1B, as well as also the communication issued dated 8/11/2006 by the Railway Board, it transpires that if in a consignment of packages chargeable at different rates, a group of packages chargeable at a particular rate is improperly described, and thereby a lower rate is obtained, the charge at 4 times the applicable freight rate referred to in clause A shall apply only to the group of packages in the consignment improperly described and not to the entire consignment. In the instant case, admittedly, there has been no misdeclaration as regards the goods of the petitioner, who is the consignee. However, on account of certain misdeclaration made by the consignor in respect of other goods, the petitioner has been sought to be levied penalty charge at 4 times the applicable freight. This has been done on the basis of a guidelines dated 14/2/2011 issued by the Railway Board. This court, upon perusal of the pleadings, however, did not find that such pleadings have been brought on record, except such specific pleadings have been brought on record, except stating that the said guidelines, on the basis of the said guidelines, the petitioner cannot be imposed with 4 times the penalty, 4 times the freight. Taking into account the above, this court permits the petitioner to bring on record by way of additional pleadings, as well as to bring on record the said circulars, as well as the general rules, as well as file additional pleadings in support thereof. The said additional pleadings, along with the documents, be filed by May 29, 2023. The respondents, including the railways, are directed to file their reply by 3rd of October. List the matter on 5th of October for further hearing. This seems to be the only way out.
Yeah.
Otherwise, this litigation is not going to end, not here. This will be a lot of litigations which will go on. Here, there.
Right.
Three.
Yes, where is Mr. S.K. Talukar? Hmm. Assembly, no assembly, but then we'll follow as per the Supreme Court judgment. Where is the judgment?
But there is another aspect since your workshop. Well, it is a point of- I think there will be a point of hard work. That as far as Article 12 is concerned, we are a civil. But that the 89 notice said the position of law has somewhat changed because of the considered the constitution.
Hmm?
97 amendment to the constitution came in actually in 2011.
Hmm.
Where the right to form a cooperative society is now fundamental. Under the same amendment, your lordship, the article 40 said, that the supreme authority of a cooperative society as regards its affairs lies with the board. And in fact, notwithstanding anything containing any other law, board can only be specific for its maximum of 6 months by the government. So, regarding the issue of pervasive control of the government, after the amendment has come in, perhaps it has to be said that it lies with the board of whatever in this call, of the cooperative society. And since they alone are responsible for the affairs of so we cannot be said to be of the authority, and on that ground also that we cannot be of the authority under the banking commission. I have
No, in fact, you see what is happening out here as I am taking up bench fire. You see, a lot of cases are being brought in only just for the sake of this is absolutely an internal dispute. Many internal disputes are being brought in the name of the register. I even don't see a provision out there whereby appointment of a secretary has to be made, can be made by the register. That provision is not there. You see, 90 days is the time which is given under 41(6). That in case they don't hold it, it is not on the basis of the register should pass an order for dissolving. No,
yes,
the register can't dissolve it
cannot be said.
because it stands automatically dissolved by operation of law in view of 1939. Now, once it is automatically dissolved, a duty is cast upon the register under 41 to see to it that the constitutional mandate for having the cooperative society is continued. And that is why 41(6) has been given only 90 days. It's a different thing that the Corporation Department at its own wish keeps on continuing for years to years. They will keep on doing that.
One aspect, as well as I just pointed out, the 97 amendment already struck down by the Supreme Court. So only regarding multi-cooperative society that has been made, that will not apply in respect of the state cooperative society.
No, let us not go into all these things, but this is the essence. Now, the cooperative society is amongst these people. So, These are private individuals who have joined together to form a cooperative society.
So, I think if you want to point out, in this particular policy, much of us have a paper capital.
Maybe
It's not,
the government may have, government may have a paid up capital out there, but then also, if there is anything else out there where the government is controlling,
except for that, run by its members, the cooperative system will run. Except, and in fact, the Alapam judgment, the word substantive financial involvement, even that has been defined by the Supreme Court. So I said that financial contribution of the government has to be such, of such a degree, and without that financial involvement,
it can run.
it cannot run.
In August 2019, regarding an LP. 2019, 9 more than 5. 19, 9.
Two thousand
2019, 9
185.
Substantial amount of finance. Eventually, Supreme Court said, it depends on case to case.
2019
9
or 9 is
yearly college trust and management society in order.
this is under the Right to Information Act.
Other firms, cooperative society has also been discussed here.
Alapam is also 2 judges. Yeah, which paragraph you are referring to, and where is the Thalapam?
Other firm, you have also defined. There are 6 madam. Other firm.
Yes. As per the definition of public authority is concerned, this court has dealt with the matter in Thalapam. It would, however, be pertinent to mention in that case, the Register of Cooperative had issued a circular directing all the cooperative society which fall within the ambit of the Act. This notification was challenged dealing with Section 2 said the legislature in its wisdom while defining the expression under so-and-so intended to embrace only those categories which are intended specifically included unless the context of the Act has been used. The expression means and includes which when a word is designed to mean something. The definition is privacy restrictive. When the word is defined to include some other thing, the definition is extensive. But when both the expression means and includes are used, the category mentioned there will exhaust themselves. The name of the expression means and includes the combined expression. Then what happened?
Then it will also come to 15, 2H has been discussed by 15. There also may come from yes, 15. There are in between there are some arguments, but
When you come to paragraph 11,
but yes. One of the arguments is for a work their government occurring in operating portion of 2H will govern the words authority, body or institution. Argued that only such authority, body or institution actually govern with self-government can be declared to be public authority. This objection has to be rejected outside. The argument is rejected. 2H has been discussed in 15 times.
if we analyze section 2H,
Can be rejected first part of the authority, body or institution of self-government established or constituted under the Constitution by any law of parliament, by any law of state legislature, or by notification made by the appropriate government. There is no dispute with regard to clause A to C. As far as clause B is concerned, it was contended on behalf of the appellant that unless a notification is issued notifying that an authority, body or institution of self-government is brought within the ambit of the Act, the said Act does not apply. We are not interested in this argument. The notification contemplated in clause B is a notification relating to the establishment of constitution of the body and has nothing to do with the Act. Any authority or body or institution of self-government is established or constituted by notification of the central government or the state government would be a public authority within the meaning of clause B of section 2A of the Act. Then 16 minutes here, comma, and that is also here, that is also discussed. We note that first, the end of subclause D, there is a comma and a big chair, and then the definition goes on to say, and includes any. And thereafter, a definition reads as body owned, control of substantially finance, non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. The words and includes any, in our considered view, expand the definition as compared in part 1. The second part of the definition is an inclusive clause which indicates the intention of the legislature to cover bodies other than those mentioned in clause A to D of section 2H.
now, if you see the last line of paragraph 17, any body which is owned, controlled, or substantially financed by the government would be a public authority.
Substantially financed will be discussed in 25. Correct.
These the findings of the law.
This one is relevant. Percentage is now important.
Whether an NGO or a body is substantially financed by the government is a question of fact which has to be determined on the facts of each case. There may be a case where the finance is more than 50%, but still may be not all the substantial risk. Supposing a small NGO which has a total area of man gets a grant of so and so. No, then what is wrong with the observations in Kalapam, where the Supreme Court says substantially financed means a finance which without which the society can run.
Kalapam has been discussed in 25 onwards.
In our view, paragraph 26, substantial means a large portion. It does not necessarily have to mean a major portion or more than. No hard and fast rule can be laid down in that regard. Substantial findings can be both direct or indirect. To give an example, if a land in a city is given free of cost or on heavy discount to hospitals, educational institutions, or such a body, this itself could be a substantial finance. The very establishment of such institution, if it is dependent on the largest of the state in getting the land at a cheap price, would mean that it is substantially financed. Merely because financial contribution of the state comes down during the actual funding will not by itself. So what was closed by Kalapam, it has been opened by him. Huh?
Because it's completely different. Kalapam says substantial means what it cannot do without. This says large portion.
So here it keeps on increasing. Now this brings me to remember that case of that. There was a small child which was having a problem with this. There's a Christian Baptist hospital out there in Dimapur, a very famous one. So there the land was given by the state, and on the basis of which now it's a private hospital. That is there. Now can I read the issues out there? Because what they were saying that they were not getting the money from this particular pastor who had put the child. So some treatment has to be meted out and what to be done. So a question arose as to whether it can be done. But I held out that as the land has been given for the purpose of the establishment, and on the basis of which the hospital came up, taking into account the other matter, you remember, there's another matter pertaining to the medical matter of just Lajpat Nagar. There's the bridge out there, the overbridge, the flyover below down Mulchan, the Mulchan hospital. The Supreme Court held out there. I think this is Arun Mishra. So he held out there that the land has been given. On the basis of that, they have now built up. Now it has become. Now whether they still have a control over that authority or would it be a state? That was the question which was taken, and there was a direction.
Yes, the article 12 will also perhaps there will be some. This is where it is the requirements. But if you have public authority under the RTI, perhaps stricter conditions have to be. But here, any public function is called function which is of some benefit the public is performed by the body. This is the requirements of article. But here you have to perhaps once the conditions are laid out, they have specifically perhaps use those conditions to come out.
Just for example, a cooperative society now is you because of this judgment, you can't just say the cooperative society won't.
Yes. Yes.
It has to be seen on the basis as to on case-to-case basis.
For example, there was one petitioners that perform some banking functions. Those are under the RBI. So perhaps there will be some aspects of those functions which might come under the ambit of a public function. It is definitely amenable to Article 12. But whether its cooperative functions is also, or the cooperative activities that it undertakes on behalf of its members by themselves, whether those functions should be covered by the definition of public authority under the RBI Act.
But can you say that it will its status as a public authority will keep on changing on the question of information which is being sought for?
That extent, there is a judgment, madam, that we have Ramakrishna judgment, which says that even if fellow discharges public function, but if the cause of action, it does not come within the relief milord of, or it does not have public element, then mandamus fellow cannot be invited. If it is followed in the sphere of private law or contractual law, even if it discharges public function, then the cause of action cannot invite mandamus or if public remedy is not available.
No, that is well established. I remember the judgment of the biri manufacturers, wherein as to whether a writ will lie against the biri manufacturers, it was held that normally it won't. But the moment they are doing something which transgresses upon the right of a person's life and liberty, then you can. Now that position has now been further diluted to the effect in that constitution bench judgment, where in the words of Mr. D.K. Das, the horizontal, which was otherwise horizontal, otherwise vertical, now it has become horizontal here also, as regards the application of Article 26.
Consequences,
No, that is seniority, but on the maintainability. The recent judgment which has come as to whether a writ will lie against a private body. That is the constitution bench judgment, wherein it says yes, sometimes it will lie against even a private person.
But the remedy, you must seek fellow that has to be a public remedy.
That has to be
Private
touching on a public function. Field. If he has, if he's doing something about it, a person concerned may not be normally, but if he has touches on something, like for example, in a writ petition where you may have a private respondent who is doing it, but he is getting his rights from somewhere, and on the basis of that, he is exercising something. Because of the manner of control which the state has upon him, or which he is being able to exercise, that may affect the rights to issue a mandamus against him.
that is discussed in SS.
But here what has happened is you have to see on case-to-case basis if we go by this judgment.
Yes, because that is this case is for
Perhaps, as far as the PI Act is concerned, now the disturbed society is definitely a public. Now, under the Act, he is to give certain information from every office. Mainly, as and when he demands an information, we cannot. If somebody wants information regarding a particular society, he may very well approach the registrar for that particular information. And if it is not otherwise barred under Section 8, then the registrar is looking for the providing. But individual societies as a whole, they would not be public authorities.
No. That will depend on the portion of finance.
Yes.
Just for example, a society has been created where the government has given the entire finance.
Yes. Then if you have,
The society can't be the government body because it won't be.
But otherwise, a normal.
Something like a national health mission. The society. In the society, I think under the 1860 Act. Normally a society against which it won't. But the entire thing is done by the government.
That is under 49(2), when one chief executive officer is appointed by the government in a society, the government will have to control the administrative body. 49(2), by the state.
There is this judgment of our High Court. Wholesale Let me understand your logic. Since one has this assumption, definitely, give this to the bank. Therefore, we will
It's a straight statement there. No, it is okay. That is another aspect. But I think we need not go into that aspect. Let us.
Language use, perhaps have language use when the Indian perhaps have some very paragraph number 11. Page 434. Thus, there is existence of deep and pervasive state control over the respondent bank. We have noted that the respondent bank gets subsidies on various accounts from the state government, and also undertakes some activities of instruction of the government, which is part of the governmental activities, such as financing of cooperative societies and cooperative banks, sending cash credit for distribution of essential commodities by cooperative sector, and making available loans for agricultural agencies. Applying the test that indicated above, we hold in this current time.
No, Mr. Padak. In fact, I have been all along in the opinion that if normally may not be in a cooperative, it will depend on facts to facts cases. To say that a cooperative society would not be a state, discharge us that to a cooperative society discharging public functions. It will be a very to something which may not be proper, taking into account that a cooperative society may do many public functions. It may have grants from the government. It may have grants from the central government. Huge amounts of money are involved. So, and on the basis of which the government has, because here it doesn't say that what is how to put it that the cooperative society has to be formed without control or substantially or any control of the government. It doesn't say. It can be formed by anywhere. So under such circumstances, it will depend. But to say that it won't be a state may be difficult.
Yes, if it is substantial, it's a requirement of.
Yes, so like a bank function.
In fact, regarding bank functions, you can ask us to have a look at what we use. Usually, there is a judgment of this Court which says that regarding banking functions, that is definitely eroded from the RBI. Now, what had happened was after that judgment was passed, petition of Article 30 was filed by several banks. Now, in that proceeding, I was filed for dismissal on the ground that this is the setting. Now, the Honorable Supreme Court dismissed the IO by saying that the right to privacy judgment, those things were not taken into account and passing the subsequent. So that
Passing the
subsequent judgment which said that the banks were amenable to the RBI Act and information sought for from the RBI. You cannot say that it's a judicial holding and you should have to have a court. So on that account, your lordship that whether banking activities per se would be covered under the Act.
maybe internal affairs of a private bank. A person's concern, how is the employee doing?
The same analogy would have to be gone to the cooperative banks also. For example, our banking functions are public functions. If somebody wants any information regarding our banking functions, then
But can you say that it is not a public authority?
as far as the RBI Act is concerned, your lordship, perhaps depending on the nature of the information sought for,
So it will change.
it would perhaps change.
If that will change, means are you saying that the definition is flexible?
Definition is not flexible because the definition of lordship would be that it fulfills the requirement of two age substantially finance, then there is no foreign. It will be a public authority. Any information whenever sought for has to be. But suppose a society which does not fulfill that requirement of substantially finance. So we are, for analogy, I'm just assuming that it's a society which does not fulfill that. So in such a, even in such a circumstance, if an individual wants some information regarding some public functions which are being performed by that society. And it approaches authority which is otherwise a public trust. For example, the RBI or the Minister of Corporate. Then the RBI or the Minister of the duty bound to provide the.
That is what. See, the register or the RBI can give that information.
Yes.
But if it is not, in my opinion, the public authority, if it is the public authority, it is the public. If it is not, it can't be dependent on the what the information. Now, an internal affair as to how our employees work, that is an information which it asks to the register. The register may not give it because it is an internal aspect and thereby covered under section 8, the exceptions of it. But as regards the other aspect, but whether for that, the society, cooperative society, if it does not fall within the ambit of it, maybe a state, maybe discharging public functions. Would it be a public authority? No. Unless you fulfill the test of the definition, you won't come within it. So, if it is not a public authority, it is not a public authority. But you can't say that it is not a public authority because it's a cooperative society. No. It has to be gone into on facts to facts basis, depending upon as to how much is the control. I think this is the manner in which one has to deal with this. Maybe it may be whether there is effective control out there or not, that is another. I'll come in 5 minutes. Huh?
Otherwise inclined to perhaps hold that. The big case would have to be examined.
Because that is what has been done here.
Perhaps the Information Commission will have to conduct an exercise, or the Commissioner will have to conduct an exercise to determine whether the control of the government in this society is pervasive enough or the financial contribution is substantive enough to meet the requirement of section 2.
Here the question of returning the file back to the or remanding the matter back to the commission may not be proper, taking into account now the other person is not interested.
Yes, but that issue, yes, all your lordship is sent.
So that has to be in the within the parameters of this DAB judgment. And that aspect has not been mentioned out there in your petition.
Yes. So those references are subsequent.
So there has to be some pleadings to the effect pertaining to section paragraph 26 and 27. To the effect that you function on your own, irrespective of what the government does. I think that is necessary. Because now in this case, what has happened out there in the Thalapam judgment, cooperative society is out. But here, the exposition which has been made here, in more particularly in paragraph number 16, paragraph number 16 of the said judgment, you see, we must note that after the end of clause D, there's a comma and a big gap, and then the definition goes to say, and includes any, and thereafter the definition reads as body, owned, controlled, or substantially financed, non-government organization substantially financed, directly or indirectly by funds provided by the appropriate government. Now then, thereafter, the words and includes any in our considered view expands the definition as compared to the first part. The second part of the definition is an inclusive clause which indicates the intention of the legislature to cover what is other than those mentioned in clause A to D. Like in Thalapam, they have only restricted to A to D.
have made some discussion about substantial financial in the later part of the document.
But their substantial thing is to the effect that the substantial is such that this cannot run without that substantial side.
It's a completely different.
But I think then also, if we read paragraph 26 and 27,
Yes.
both can be jointly read. Both the judgments can then jointly read with paragraph 26 and sub 27, wherein it also shows that if a particular body has been substantially would not mean only running, but also would it be able to function without the initial capital which has been given. This is what has been mentioned, paragraph 26.
Initial capital will also be.
Just for example, the entire capital was put by the government. Initial. The foundation is on that, and thereafter you started. Then what happened? Could it be a public authority? Let's see paragraph 26. You read it again.
Now, the substantial means a large portion. Does not necessarily have to be a major portion or more than 50%. No hard and fast rule can be laid down in this regard. Substantial financial can be both direct or indirect. To give an example, if a land has is given free of cost, but heavy discount to hospitals and the body. This in itself could be substantial finance. The very establishment of such an institution is better than the largest of the state the land at a cheap price. Even that is substantial finance. Mainly because financial contribution of the state comes down with the actual public. It will not by itself mean that it's given and that's given not to be taken plus. Value of the land in absolute value not only about the production, but even of the investment and actual capital that the state value is.
So you have to see initially, or could it have started without the government's help? Mr. K.P. Pathak, the learned counsel appearing on behalf of the petitioner, submits that in view of the judgment of the recent judgment of the Supreme Court in the case of DAV College Trust and Management versus the Director of Public Instructions reported in 2019 9 SSC 185, he would like to take further instructions in the matter and if need be, file additional pleadings. List the matter again on October 3rd for further consideration.
Atlam code.
Lordship, please come to the gazette notification of case lordship of the.
So you are challenging an order passed by the Assam Board of Revenue.
Lordship. That is at page 36 to 39.
Page 36 to page 39.
That basically that judgment and order is saying that the notice was not served and it says that the delay in control is evident that the appellant or the other successor of the particular got no notice. It is not a fact, my lord, because the government has here and lordship, that lordship is against full lordship at page 33 annex of 5.
You are the owner,
I am the option person.
you are the purchaser. Section 74 of the Assam Land and Revenue.
Yes.
And section 5 of?
Sir, wrongly put, I have not got any of it.
Hmm?
Tried also. Section 5 of what I do not get lost. Section 5 of the kind of.
The section 5 is different.
It's a different process. I don't get it lost. Honestly, I have to say, but I
Section 74. Just, it's a short judgment, let me go through it.
Yes, then I. What's in it? It is the annexes C.
Yes.
The regulation, it is their lawsuit that it is published in the official gazette. So gazette notification is free.
How did you come to know? How did you come to know?
It is annexed.
Now, how did you come to know about the date fixed for sale?
We have our land next to that.
No, how did you come to
My
know?
client have some property there next to that.
Maybe, but how did you come to know?
Because
It is not,
they have given
is it pasted in the land that the land is going to be sold on
Yes,
this
yes, there is
particular
a
date?
notification. In the office notification.
How did you know that it is in the office? Because in the gazetted notification, there was no mention about the date.
Landowner, I visited the office very frequently, lordship.
So you were interested in the land.
Lordship.
You were interested in the land.
No, not that way.
Now, how will the other people know?
Other people also have come. I am the highest bidder.
Understood, but how did the other people know that this was the specific date on which it was fixed for sale?
They have given notification.
Where?
In the office here, lordship, as per the procedure, they have given notification.
Notification is given to be given where? Let's
The
see.
office notice board.
Where is it?
Lordship 72. It is notice to the then it is started. Lordship, how it is.
Which will be sold and the time and the place of sale, the revenue assessed on the property and any other particular, a list of demand. Shall be published in the manner prescribed. Where is the manner?
That lordship will be.
So it will be there in the rules.
Yes. Lordship will.
Where is it?
At 137, lordship. It is rule 135, form number 38.
Statement of the list of estates to be prepared of the
Is that
in
you can
respect of
tell me,
property to be sold as shall be prepared in the language of the state and mean. So it will be done under as per 136. It has to be done in the court of the revenue officer by whom it has been prepared. At the office of the sub-deputy collector in whose circle the estate is situated. At the office of the Tahsildar or order of the house of the Mozadar, where whose Tahsil or Mozar defaulting estate lies, where the Gaumburas are employed on the signboard of the Gaumbura within whose charges the defaulting estate falls, at the offices of the Gaum Panchayat and the Anchalik Panchayats.
Now,
The sales statements of
here lordship, here in 137, they have come that they did not give the notice of being there after the case. So
Hmm?
that is the case. Now, before the revenue board, the people they have come, they say you do not get the notice that the my property will be sold. That is their case before the revenue.
Hmm.
They have not taken any other point. That the revenue board has decided.
Revenue board can exercise under 151 that power.
Yes, sir, 151 power in the.
So then,
In our case, it is 151 is not there. He has not been here. 151 is not there.
not necessary. The revenue board has the power.
Right.
Then,
But lordship, then lordship, my point, is the lordship, the record has sent. Record has come. Now I have said, lordship, the record is not there.
the record is there.
Record, lordship, may please come before lordship will check the record, lordship, may please come to case 30. For my repeat. Then
Page-
lordship will. Without those things are there in the.
Page
Page
30.
33, annex 5.
Yes.
These are the document to send. And in the LCL, it is not there. Even the para 4, they said the accountant, Mrs. Selima Azir received the notice with the signature on it. Now there is an enclosure, Lordship, in the next page, 130 page 34. These things are not there. And that is why Lordship, this court passed an order on 24/2017. Yellow flag Lordship, yellow flag.
Where is the records of the,
It is not there. That's my problem, Lordship. I want to show that because in this here, Lordship, it is said that is why this court passed an order on 24/2017. Lordship, it was pointed out, Lordship, before this court. And this court passed an order. Lordship, let's check the page 23 of the years. LCM, page 23.
which is the district?
Lordship, Kamrup.
Kamrup where?
Rural. Not that. It is not. Payata Sadeh, there, Romney.
Yes, Mr. Talukdar. Where is the records pertaining to this? The deputy commissioner?
Lordship, no, please, simply sort out. In the court order is there.
No, Mr. Sharma, forget about the court's order. Let us not look into it. This has been done 7 years back. We are not concerned with those. Where is the records pertaining to the auction site? We'll take a call at 2. Just ask the deputy commissioner here. Huh? Anyways, give a call and find out where the records is and when can it be produced, so that we can take up the matter again next week. We'll take it up again at 2. Because these matters, otherwise nothing happens. If you don't press this person's concern. Because your affidavit I have looked into just now, you only say, Mr. Talukdar, why I'm saying one thing? There's a manner in which it is to be published. In the Gazette notification, there is no date mentioned. It only says it will be sold after 1 month. If it is to be sold after 1 month, How does the people know? The dates are fixed. Because here we are not concerned about a small 1 bigha, 2 bighas land. 1,000 bighas.
No, no.
How much?
200, 200,
279 bighas.
not 1,000.
No, 280 bighas. Which have been sold at 1,000 rupees per bigha. So we are concerned with that because this is of the year 2008. When was it done?
2007.
2007. 2007, 280 bighas sold at one.
Not many cases.
And also, we also require the revenue circle land. The revenue circle rate of that land.
Yeah.
But that is a very vital issue.
Yes. Yes.
Can it be 1,000 rupees there? In 2007, 2008. And if it is there in this Kamalpur or whatever, where is that?
Why at the Kamalpur?
Where the 4 laning started.
Not in. Yeah.
Now you don't get bigha is the crore with that road, the bridge coming up. We are concerned in just 15 years down the line, the sale being made at 1,000 rupees per bigha. The circle rate can't be 1,000.
Because nearby land, government has given permission for sale.
We'll take it up at 2. You call up your deputy commissioner. This is the records, you know it. In respect to this, when he can produce, I'll pass the order at 2. Fixing the date. But that records has to be produced.
Number 6 to 16 and many other. They are the courier holders. Occupancy tenants of that land. Agriculture. They are cultivating the land. They are staying in the land. But they have got no notice regarding and according to that some temporary reaction there. They can obtain the rights of that ownership rights by paying the premium as fixed by the government. But they also did not get anything. Our affidavit is there, regarding notice.
Did you file an appeal against the sale?
No,
No, we have,
No.
we did not get any.
that part I will.
No, what are you doing here?
But we have, we did as,
No, you got yourself impleaded before the Board of Revenue?
No.
no, because we did not get anything, we did not know anything about that.
Okay, no, Mr. Chakraborty, we'll take it up at 2. We'll get that information, then we'll fix it. Then because you're right, it will be under 21 or 23. Depending on whether in 23 you are personally cultivating or not. If you are doing it, then you can very well, no, but even if he becomes the owner also. No, if he becomes the owner also, you can get it.
Yes. We have applied already.
No, have you filed any application?
Yes, we have already, because of this case, that application is pending. And for that, I have filed one business that last time.
We are not, they have applied for Patta now. They,
No, they have done it for the purpose of the occupancy right, the rights of under 21 and 25. Finish.
That is pending.
We'll take it up at 2. Okay.
5 and 6.
Yes, Mr. Nath.
So 25 states will go through.
I've asked them for the proclamation. We are not going into those trivial aspects. The question out here is, as to when the proclamation was made, did you file any objection therein? Were you there at that point of time when the proclamation was made?
My question. When the proclamation was dated 29/9/89,
Were you there?
I was there at the time. Now, whether, as per the resolution 6, my lord, and it is sent to court, my lord. 6, my lord. That says, when a notification has been published under section 5, the forest officer shall
Hey, Khalid, some forest man. Yes.
section 6, my lord, regulation 6, my lord.
Hmm.
Proclamation by forest.
Yes.
When a notification has been published under section 5, the forest service officer shall publish in the language of the country and the headquarters of each district and subdivision in which any portion of the land comprised in such situation is situated, and in every town and village in the neighborhood of such land, a proclamation specifying as nearly as possible the situation and needs of forest service. But there's a procedure by law, the local languages needs of office is my God. If there is definitely if they follow this or my God, but publication notice, other things my God, copy newspaper my God, obviously my God, I know the part.
Huh?
I don't have it. Suppose they have done it, they have followed. Just for the judgment.
No, are you challenging the proclamation notice?
I'm not kidding.
You are saying that you should not be evicted. You are there. But the fact that there is the proclamation as of now, it is the reserve forest. Now, can you say that you have a right over the land? After it has become a proclamation, because the right, you can't accrue any right over the land after the proclamation.
Once it becomes a minor.
Because as of now, they can't give you a settlement.
No, they can't.
They can't give you a settlement. The only way out is to give you a rehabilitation at best.
Yes,
Nothing more
yes.
than that.
My lord, that.
Isn't it?
Village, that
There cannot be a question of settlement because as of now, no right has accrued upon you unless in the proclamation, prior to the proclamation, you have accrued. When you are not challenging the proclamation, the right which will accrue upon you now will be only a right best to get rehabilitation. Or now I'm told that as regards Silhaku, they are paying 10 lakhs and 5 lakhs. Let them pay you some money.
my lord, only one thing. my lord.
I'm
My lord,
coming up to,
my lord.
yes.
If it is.
ফোন নাম্বার কোথায় কোথায়
Then this is the old pending matter. You have to get. This is an old pending matter. Today is 12. We want the records on 19th.
On
19th of September. Okay, let there be another one. Whoever it is, there's no other council
Yes, yeah.
introduced. How do you do? Local record.
I don't know, my lord, only my lordship.
Hmm.
You can check the page 41. There is a so moto matter already taken up by the revenue board. Maybe revenue board has all the record there for that matter. Lordship has seen that, Lordship has said that 1,000 bigger of land. I got your point, Lordship, I am 280. The rest of the thing is less than 1,000 rupees, so they have taken a year in so moto loss, the revenue board. For rest of the land. It is 1,000 bigger, Lordship is very kind. And but then those are less than 1,000. And then the revenue board has taken a so much. So maybe, I don't know, I'm not saying that they, maybe the record is there. That is why there's a problem. There's an order passed at page 41. Of it.
Yeah, yeah. In fact, it's around 1,200 meters.
The rest of the thing, they have taken so much of us. Maybe I don't know, also. I'm not saying that. Probably. But you can check the page 23 backside. Page 23 backside. Those are the documents. Backside of the page 23.
The matter upon being heard transpires and upon being heard and the records being perused, shows that the records pertaining to the auction sale made on 4/5/2007 in favor of the petitioner by the Deputy Commissioner Kamrup Metro, by the Deputy Commissioner Kamrup Rural, is not available. However, the records pertaining to the revenue appeal number
45
RAK 2009 is available. This is a very old pending matter. give a highest. When was it restored? This was dismissed for default.
Yeah, it was by 2 orders, did not once, twice. I do not have the record of it. I have only get the
IIT was-
7/6/2019 it was restored.
last time too. This is an old matter and requires an early disposal. Mr. Talukdar, you won't be available on that date? Where is, just now I saw Miss S. Sharma, where is she? Yes. Taking into account the above, this court fixes the matter on 19th of September 2023. The Deputy Commissioner Kamrup Rural is directed to produce the records pertaining to the public auction held on 4/5/2007, whereby pertaining to the auction sale held on 4/5/2007, which was the subject matter of RAK 45. Pertaining to auction sale case number 2/2006-707, which is in relation to the RAK case number which is in relation to appeal case number 45 RA bracket K/2009. The Deputy Commissioner Kamrup Metro Rural is also directed to inquire before the learned Assam Board of Revenue at Guwahati Board of Revenue if the files cannot be traced in his establishment. If the records cannot be traced in his establishment, in connection with 6 RAK/2011, on the basis of the instant order, produce, the Secretary of the Assam Board of Revenue shall hand over the records, if records pertaining to a auction sale case number so and so, to the Deputy Commissioner, Kamrup Rural, which in turn shall be produced before this court on 19/9/2023 positively. A copy of the instant order be served upon Ms. S. Sharma for due compliance. No. 19. Let us see on 19 if we get that records or not. And who is paying for the main person? The appellant, at whose instance the appeal has gone.
I'm the respondent number 5.
You are the person, you are appearing. Where is the records? Not interested. Then? Okay, we'll have it on 21st then. Miss Sharma, we'll have it on 21st. 29, 19. The registry is directed to list the matter at the top of the list.
I haven't seen.
Records.
Here, my notification was delivering notification progress, and the DC Kamrup was appointed as settlement officer. Yeah, but.
This is the proclamation. 89.
89.
This 89 is for which one? Down below.
Done. And smart gadget management.
This is made as South Kalapahar Reserve Forest. How do we know that these are the lands where the petitioners are occupying?
Madam, there are other reports, madam, after this institution of this metal case, madam, we had conducted a survey. As of now, madam, within the notified boundary, 6 of them fall under the notified boundary and 9 are other out of the boundary.
So the 9 are outside the reserve forest. So that is another aspect for them.
6 are.
How many petitioners are here? 16. 15. So 6 are within. Who are the 6? We are concerned with the 2012 petition.
Interestingly, while being then information has a statement of that 2007 order, they have admitted that they are paying Tozi.
That's okay. Tozi is a different thing. You come in the scene if it is a reserve forest. Isn't it?
In my file, logical file record, because section 5 notification was published in 1968.
Understood. Everything understood. Now, therefore, I'm asking you. You see, 6 fall within the reserve forest. So if it falls in the reserve forest, I think Mr. D. Gogoi comes into the scene. Otherwise, no. Who are the 6?
Corona Sohoria, Corona Sohoria,
Corona Soria, number 4, yes.
Ramneswar Kolika,
Number 1, the lead.
Ramesh Barua,
Huh?
Ramesh Barua,
2,
Anil Talukdar,
5,
Ines Das,
Dinesh Chandra Das.
Ines Chandra Das, Jagadish Pathak,
Jagadish Pathak.
Ismail Hussain.
1, 3, 4.
Not a lot. I'm reading my otherwise. These 9 people like
Outside.
no 9 are inside. 9 are inside. And I thought page 44 of the activity. The third
Of which affidavit?
12/2/20.
I'll buy.
5 by the chief secretary. Page 44 is very clear.
Well, to well, 2.
Yes. 12 March. Sorry. 12 March.
12 March.
Page 42.
Page
42.
with reference to the letter number so and so, we have carried out the topographical survey of the TPS caliber and completed it. During our survey, we have taken boundary pillar edge so and so. Further, with the GPS provided to us for disputed location while plotting the land, we have found that some location falls within the forest boundary while others falls outside the forest boundary as mentioned below. So 1, 2, 3, 4, 5, 6, 7, 8. 8 only.
No, 9, still not 13 also.
Oh, 13 also. So these are inside.
Inside.
So inside, what to do with them?
This report by this time is top minor. Top there is a precise DN something minor.
Huh?
The top and is the left side. Capital letter.
Precision.
Precision. There is also that is that the agency was given the job of conducting this survey.
They do it through GPS
Yes,
coordinates.
now I just amount to things to what is one particular line. Serial number 13 minor, Ashwini Choudhury the same 13 inside forest boundary. Now in the affidavit filed by Chief Secretary on 26/2/18, it shows Ashwini Choudhury found outside notified boundary for South Carolina. There are 2 reports I said the other day submitted by one.
It's okay. Let us see the actual report. Where is the actual report? Where is the actual report?
Now, which one to be treated as correct?
Where is the report?
there records of the.
Oh, he is not there. Mr. Procedural is not there. He was supposed to be there.
There is a court appointed commission that is scheduled in the High Court premises. He has to go. Therefore, I appear on his behalf that it is the.
Where is the report? Where is the report in originals?
So, he keeps secretary will tell you what.
Where are the reports in originals? So they have the records.
I will see the first page of that report. There is some, so I have this report. The first page is states regarding verification of 2.2 report. Committee of the committee is taken to look into and it's a committee of the committee report that just to come to.
Okay, now as per you, number 13 it falls within outside.
Their reports.
No, it's okay. We will treat it as it is. It falls outside. Now,
Still there are 8.
huh?
In that case also there are 8. In that case also there are 8 inside.
Who?
If suppose possibility to.
8 is outside, inside. So let us take as per your report what it is, because they have failed to produce the records. So we will take it as 8 are inside. Remain. What about the outside? Outside forest boundary, Mr. D. Gogoi has nothing to say. Okay, now what does the revenue has to say out here as regards outside the boundary? We will take number 13 to be outside the forest boundary. Because their report, which has been made on the basis of the High Court's order, says that he is outside. What do you have to say?
As part the activity filed by department. It says that none of the petitioners were there at the time of the proclamation. They were.
See, proclamation, I have already done it. That is 8. 8 are inside. So once the 8 are inside the forest area, they cannot be given any settlement out there. So they cannot have any right over there. So they are to go away. That is one aspect. Remaining comes is another 15. 8 and the remaining are 7. Now what are the 7? What do you have to say on the 7?
They are only paying revenue, that is the paying of this disposing.
So they are government, they are standing on government land.
Yes.
So under such circumstances, what are you going to do with them? They have permanent constructions. No. You see, there is a question of rehabilitation. If you want to do it, that is your lookout. This is none of mine. You have a land policy out there. You want to rehabilitate or give 10 lakh rupees, which you have thought for other ones. That you can think about them. If they have permanent structures, give them 10 lakhs. If you don't have permanent structures, give 5 lakhs. That is your state's policy, isn't it now? You have recently given 75 lakhs to those people. Huh?
Yes,
Not an announcement, there's a notification. Announcement. The government has already sanctioned this 75 lakhs. If you are paying to the others, why not them? What are humans? Are you going to treat them differently?
I just want to be what motion besides this fact.
Ah.
In page number 25, it was a certain order. The order was my lord by the book. The regular department to look into the matter and to suggest to the government that action to be taken to resolve the dispute.
There is no dispute, Mr. Nath. No, Mr. Nath, first and foremost, you are in government lands. There is no dispute. The only dispute is how to be rehabilitated. Either they have to give you settlement in that area, or they have to give you rehabilitation.
So,
Some.
number of orders, my lord, Washington repeatedly asked them, my lord, in 5 or 6 orders are there, my lord, to resolve the dispute, to explore alternative arrangements for recommendation of the petitioner, we release various data state as order, my lord.
Understood, but the thing is, they also have to get lands. Would you like to go to Dhemaji? No,
So, let them come check.
there are lands out there in those places. I also see that day I was going through Karbi Anglong, there are lots of lands out there. Would you like to go there? Then
But this one,
empty lands are there.
I'm not saying, let them come and.
Karbi Anglong has 70% of forests, so they are 22%. Then also there are empty lands. You may go there.
By submission, maybe our submission is my lord. Let them come and take the process, by the that there are lands on both sides. Let them come and say, my lord, whether there is a land available or not, let them say.
No, it is not the question of their land available or not. There is a question is that you have to file applications for allotment and then they have to consider it. Till they don't do with it. Otherwise, pay you compensation of 10 lakhs each.
In the second case, my lord, I find it.
Because they have allowed you to stay all along. And here the
40
other
years.
one, the forest will pay this 10 lakhs
40 years.
if they have been remaining. You pay 10 lakhs.
Second petition, there is a petition, there is an application for allotment. The second petition, there are applications for allotment. Second.
So they have filed applications for allotment for that land. No, forest area, you can't get an allotment. There cannot be a creation of rights on that. So there those goes. But then also those people needs to be rehabilitated somewhere. We have the senior government advocate. You tell me, you are paying this 10 lakhs.
Inside people, they are the what is the take care of. Now that one thing document that in 68 at the time of 68 at the time of the first steps again, they were not there. They entered the first step subsequent put in from the record first record ultimately they have to. In respect of the outsiders,
No, that is why I am saying they are not entitled for any settlement there. They cannot, they don't have a right not to be evicted from there. Because no rights can accrue upon them on the forest. These are there. But the thing is, you are a welfare state. And being a welfare state, you have given 75 lakhs to others for 7 families. Why not here? No, forget about forest, you, the state,
for the outsiders,
8, there are 8 who are outside.
the outsiders, the it is largely that is required for the state of that. The land is at this stage for the land is they have filed application for settlement. That is possibly what is.
They have a right, they don't have a right, but they have a right of claim to be considered that they should be settled. They cannot have a right that they should be settled to A, B, C, D land. No. Your settlement policy is 1 kata 10 lechas as of now, isn't it? So 1 kata 10 lecha is the land which you can settle to them at best, nothing more than that. So as of now, their applications are pending, those 8 who are outside. So they should not be disturbed immediately till you consider the application and give them whatever rehabilitation is possible or not. But what about the other remaining 8? You are a welfare state.
So the persons who are inside the forest area, ultimately the forest area has to be cleared.
That has to be clear. There is no worry. Because there, the question does not arise for settlement of them out there. There might be a settlement here in respect to them, in respect to those people who are outside. But inside, there can be no settlement. The question of settlement does not arise. So under such circumstances, they have to be removed. They have to be evicted. Now, if we are evicting them and allowing them, what is the course of action you are thinking?
That part I have to say. Otherwise, from the forest area, it is, they have to be evident, what will be the rehabilitation as well as compensation, what can be done. I have to, I am not, at least it has.
This has to be done. Unless otherwise we can adjourn this, have the status quo out here and adjourn this matter sine die to be listed after 2035 when I retire. Yes.
Forest department, this thing now. I'm not, I have to.
As of now, Madan, we don't have a.
They don't have.
Compensation.
No, it is for you. You are the state. You are the mighty state.
But I don't have right now.
Because whatever may be, the state may not be concerned about preserving the forest areas. But if they are concerned, they have to be more. In fact, this matter should have been more taken up on right earnest by the state. It seems that the state is not, state should come up with proposals, not for this court to give proposals or give ideas for the proposals.
Sir, I have doubt on whether the revenue department is going to pay them the amount. Because they are.
Whether they pay or not, you see, the problem which arises is for 8, there is no problem. They can give a settlement there or may give a settlement somewhere else, whatever may be. And there is no urgency of throwing them out. But as regards the other 7 or 8, 9, 8, they have to be evicted. They don't have a right. And this court cannot pass an order not to evict them if they are in occupation of a reserve forest. So how do you meet both the situations now? You being the senior government advocate, you should have the, you have the, maybe the forest department, maybe various departments, but overall control is yours. And you appear for the chief secretary. Then the chief secretary, and that is why the reason the court had directed to resolve the dispute. That is the reason why. How to resolve this dispute? And why does it take 15 years for resolving this dispute? Should we adjourn for another 15 years at your request?
No, but I'll not request that. Only one of the insiders, what can be done from our side for the insiders.
Something has to be worked out because they cannot, they are to be immediately thrown off. And your government is sleeping, isn't it? From 2008, the government has been given the liberty to take a call. What have you done all this while? You are to take a call what is to be done to those people because they have to be. And now this is an immediate case where these people are to be removed. Not about the others who are outside, but inside they are to be removed. And because of the orders passed by this court, they are enjoying, which is leading to deforestation. Then what to do?
Otherwise, I'm not talking about.
It's very easy for this court, throw them out. But would it be equitable? Just to say, throw them out. They have some rights. Even the matter which went to the Supreme Court regarding the challenge which was made, na? What is that? They were not a psyche or something. This matter went to Supreme Court. There also, the Supreme Court said, now the eviction has been done, we can't say anything of that. But however, as regards the other aspects pertaining to rehabilitation, the DC has been directed to take a call, isn't it? There is some PL matter which went to the Supreme Court. So, when you are coming back? No, you are appearing for the chief secretary. Understood? The chief secretary is the boss of everybody. So he has, that is why there was a direction that you resolve it amongst yourself and find out something to work. And therefore, the committee was formed. to that effect that it will include the forest official to the death. You have found out, discerned out there that these out of 15, 8 are in forest, 7 are not. But what is the next course of action?
Eviction and amenity eviction, what can be done? Ultimately, what will happen to that amenity?
For the rest 7 days, no problem. This court will pass an order to that effect that they have already filed that you will consider till you come up with a decision not to evict them. That an order would be passed to that effect. What about these 9? They are to be evicted. I can't say that not to evict them.
Eviction will be there, but
No, here I can't. At regard 1 to 9, I cannot say they're not to evict them till now because that is the mandate of the law. That they cannot be created after it has been a proclamation has been given. And if I start doing that in this matter, it will be in all other matters. This is the same precedent which is going to follow. And Mr. D. Gogoi will have a lot of problems. Isn't it, Mr. Gogoi? Yeah. So,
let me in the case of forest land not let me what can be
14, 1, 4, 14. Then only things will move. You only find out what is to be done in regard to those 9.
inside.
The remaining, this court will pass an order to the effect. But what is to be done with these 9? Can you say that they have to be removed? You may give them 60 days time for removal. And in the meantime, you may consider giving them some allotment or pay some compensation, whatever you may think. Whatever maybe you may think to do in equitable, because you are a welfare state. But if it is a case where they are just mere trespassers, it's a different case. But can you say them to be mere trespassers when they have been there from 2008 getting orders from this court?
Ultimately, if in this particular case for 8 or 9 persons, the other takes comes up with everything, that will be followed for.
This is what problem you are going to face in Sialkha. In that Silsaku matter, you are going to face the big problem which we have done. Recently, there is a sanction of 75 lakhs which has been given. It is there everywhere. Somewhere I saw it. There's a notification that the government has already sanctioned this amount. Now, if the moment you are doing that, it will have far-reaching consequences in all matters.
In all matters, because these are forest land, if for the emission of the encroachment from forest land, ultimately the government has to pay money to the person. But any decision has to be taken from the higher authority.
So you may think of giving them 3 months' time. In the meantime, if they are there from a previous period, think about giving them an allotment somewhere, somehow, if they have a right. Otherwise, they don't have any rights. Or something to be come up with it. Because I don't think they have a right for these 9. Others also. But if these 9 are there, if the other 8 or 7 has a right to remain therein pending their decision of their application, wouldn't the same yardstick be applied for the reserve forest also? Taking into account that in government lands also, nobody can enter.
For amendment, I'm not taking any submission because so many cases we have seen that the persons are occupying government lands for years together and cases have been considered. In some cases, settlements are being given in some law. But in respect of forest, this is an issue where I have no idea what is the policy of the law.
You come back on Thursday. We'll take a call on this. What is let me also think about what.
If there is any existing policy with the government, yeah, regarding-
There may not be a policy for the government for forest land. But what is the best equitable thing can be thought of? Best, at best. I'm not saying that you have to allot them, no, because that will also have a far-reaching consequences later.
Because lot of
Yeah.
policies there.
So everywhere, just for example, in Pubitora, there has been a lot of the encroachment.
Pavitra, Amchan, and so many of the.
So everybody will ask for. So did they have, you, Mr. Gugoi, you check out from your records. If you have anything out there from these records. From where they have started, they make their claims that they are there in the forest area. Was it prior to the notifications? So once the proclamation has been given, then they can't make any claim. Maybe they may be there from 89. The forest have acquisition, but there cannot be an estoppel or a waiver or a, to that effect by the state. That is the principle of law. So you have a look at these documents to find out from where do they claim their right from? Or is there anything documented on the basis on which various records, they must have filed some applications to the effect. Have a look at it.
For instance, I have a judgment of eviction bench. These are my tribal communities that came for reservation under 2006 Act as the they were living for hundreds of years. But this honorable court held, since there's an encroacher, chase them out. That point was also raised. That regarding my has raised this compensation, this kind of issue. That was not addressed. Tribal communities were living in forest, dependent on forest. From my generations, they file a PI, give us the rights. We are so and so scheduled.
But you have that act.
I have the act.
No, there's an act for the forest dwellers.
But I'm trying to think of this code is one of these, they were stealing, scheduled tribe.
Maybe, but you have that forest dwellers act.
But under that act, also they were not given any kind of relief.
Somebody may not have given it, that's a different thing. But can you say that if the act is otherwise permits not to give them the rights?
Plus, there was examined, so near by this honorable court matter. Court said, one of the court said, since there is a mechanism, you didn't reverse to that direction, you didn't take benefit of that process. Now, after everything is examined, claims have been settled, you cannot claim any right. And even directions are issued to the chief.
Okay, you bring up that judgment.
Yes,
We'll have a look.
I can give him my.
No, you give it tomorrow on Thursday. List the matter on so and so for further hearing at the top of the list. Records have been produced by Mr. D. Gogoi. Is returned to be produced again on Thursday. So do they? Anybody know?
No, 7.
Yes. Oh, yes. Where is it? Oh, yes. Jangan pulok. Both of you have not seen this. তাহলে box নিতে। হ্যাঁ। No, no. Pursuant to the order passed by this court on 29/5/2023, pursuant to the order passed by this court on 11/4/2023 and 29/5/2023, the commission so appointed had submitted its report today, submitted a report dated 5/9/2023. This court duly appreciates the this court duly acknowledges its appreciation to the members of the commission in submitting the said report. The said report is kept on record, is made a part of the record and marked with the letter X. The parties hearing, the registry, and the parties hearing before this court are given the liberty to obtain certified copy of the said report from the registry of this court. List the matter for further consideration on. Otherwise, everything has been done. So here, the report says that you have tried your best to do it. So the report is in your favor. So that is there, but you may have they may have a like to see out there. But the fact that on assessment of her current disability, the commission noted that the child has the following problems. Her vision is severely compromised. Severe imbalance hampering her ability to sit, stand, or walk without support. Bilateral foot drop and right wrist drop. Difficulty in communication due to unclear speech. She is not able to perform daily basic tasks like toilet needs without help. So this will require these things, and the lifespan of the such persons is around 50 years. List the matter again on 20? 20 not possible. Huh? No, it's okay. We will have it on 26th. List the matter on 26th of September for further consideration. You can also certify. Pick it from there. Hey. Oh, that one. Yes. Huh? Then
online FIR. Then by personally visiting the police station, they have submitted the. However, if you also see the online FIR, because posted on 16, and this document is on 15, 24, 15, the written FIR is there. What was the necessity to file an online FIR? Minus this document there, what was the law? This is 15th of December 2016. And the online FIR has been posted as per the record, but posted on 15th of December. And then prior.
how do you say so?
It's there on the.
Where?
Procedural kindly control is required. I think it's 51 running. The online version is fine.
It was posted on 16/12.
Yeah, you can do. And the written version was acquired there affidavit, there are 3 affidavits. It was submitted on 15th. So 15th was written FIR was submitted. Why don't they say necessity about?
But there is a date of 15/12 at page 69.
Assigned it.
Understood.
That is your objective. On 16 your objective is the investigating agency posted it. We need to file it on your objective. We don't post it. This is a format your objective. That's senior. They have your objective posted it on 16.
So they posted. So when did you approach?
I approached your objective. Initially, I on 16th, I submitted that your objective.
Huh?
Can you take the
How are you?
Yes.
page 41?
Yes. Tell me that I lodged an online FIR
Yes.
against the present petitioner wherein I was asked to submit a brief synopsis of the entire case within a specific word limit.
So the online FIR was submitted first.
When did you submit that?
That is on 16th itself, your Lord.
Why haven't you mentioned the date? What is wrong with your drafting people? Yesterday also in that matter. And knowing fully, I understood that matter was taken up by at the time when this court was not there. But now, when this matter, this affidavit has been directed to be filed by this court, then obviously you should have been more careful. Why haven't you not mentioned this date? The moment you are saying subsequently on so and so means it has been done subsequent there too. How can I say it to be on 15?
And the assigned your objective date is your Yes.
Now the case diary is already, the case diary will form a part of the charge sheet. So
Directly on your side, but it is not our case that we have not said that they have hide something from this organization. What I have pointed out to your worship that from the record your worship, the details of the allegations your worship that was your worship as shown in the FIR itself, copy. It forms part of your worship, the details which I have submitted. That is their that they also have admitted that main complaint is annexed to the. And secondly, my case is your worship that your worship, when assuming that this is the FIR, your worship, even then your worship, FIR not being the your worship encyclopedia, and the other materials that have come up, your worship, during this, in totality, if we see, then there is a case under section 406 or 420 or whatever the accused persons. That is my case in nutshell. And finally, your worship, since
No, because you see, just for example, here, these amounts at page 59, running page 59. These amounts have been paid to the petitioner of 5 lakhs. 5 lakhs, 2 lakhs, and 3 lakhs. So that is this 10,50,000. Out of which 5 lakhs have been paid to the petitioner on 2/2/2015. When was this paid? Two 2015.
in 2015 your worship, to IDBI check transferred rupees 5 lakh, which was dropped on accident. Cooperative. I transferred the money to accident account, also again on 11/10/2015, transferred an amount of 50,000 from accident. Naya amount via ATM, revenue loss for accident, account number. And 44 your worship, detail I have submitted this for the
Page?
is for running
Okay.
first and then third.
Told me that according to his paternal cousin brother Rajiv Shah, Rajna gave job to almost 10 candidates, male and female, in Indian oil corporation. Mr. Patwari, from a reading of the detailed FIR, is a case made out. When that particular document shows that it is a part, there's a the detailed document is already there. The problem has arisen because you have filed a petition here. Because the problem now which this court is facing is because the Jharkhand is not bothered with such small litigation like this. They are not going to keep any person out here. So they are not there. They are not producing the CD, nothing to the effect. Now, as regards the other one, the case study, if it has to be called for, this matter goes for again for a 6. How do you get hold of the case study and the case records, the charge sheet? Why haven't you filed it in Jharkhand? You would have very well filed it in Jharkhand. There was no problem with that. If you can very well go out there and file it. The problem arises out here because of that. If that document, the entire set of the document, the 4 pages or 5 pages would have been typed out and placed before this court at that point of time, this court would have then asked that this particular what has happened out here. They're also in the certified copy, it still maintains.
Including the charge. Including the charge. It should have been there. I can produce a certified copy of the FIR as well as the charge sheet, that's why I was taking it.
But the FIR, the certified copy of what you have obtained, there, the still that where is the endorsement? How does the endorsement come in?
While the endorsement, endorsement means the online FIR is the main basis. And other documents are enclosed. So, if the FIR was, and there are 3 minor because online FIR was submitted by the subsequently
What?
online FIR was submitted. Percentage is submitted the detailed copy is the subsequent document.
Now, let us assume this to be the initial deposition or the statement given before the police by him. This is the 161 statement made before the police. FI cannot be an encyclopedia. So if this document be treated as a 161 statement and on the basis of it, can it be quashed?
This document can there is another way. Subsequently, also, this document can come to the notice of this police investigation. They can make
The problem arises because we have filed it here.
under Article 226.
Understood, but if it is under Article 226, the moment there is any problem in getting these records out there, why should this court interfere? Tell me. The problem which is arising out here is this court has, I don't know whether out there in Jharkhand, should I call for the records of the charge sheet? The moment I call the charge sheet gets stayed.
There also kind of an investigation was carried out during the currency of the state population.
No, this was the stay was till a returnable date. Thereafter, you did not inform the authorities. Was it until further orders? Then did you give it?
We immediately completed the order.
Understood. Thereafter.
Oh, the investigation was not carried out thereafter. It was carried within the currency of the state.
How do you say so?
Because the order of the commission based on their reflection.
What did you say? No, not there. Here the stay was operating from when to when?
So we kindly come to you based on
Until the returnable date. Returnable date is 26/5/2017. Are you saying that till 26/5/2017, the charge sheet was submitted?
It's submitted later on.
Then, did you inform thereafter the order? After that, did you inform them? No. It was only till a returnable date. You have informed. And Mr. Gautakur, why is he saying that this is not a part of the records? This document of 15/12/2005.
That you wrote it. That you wrote it, I don't have the particular copies, I have not applied that. And the art sheet, etc. also I have not been given.
See, the only way it can be solved out here is without undue delay, if you can obtain a certified copy of this 15. If you have a certified copy of the 15/12 thing, obviously then it becomes a part of the record. So there, because otherwise from this, in my opinion, the case is made out.
That is the work of some time ago. After that time.
Because the records otherwise, what is there? Because there was no stay. He has not communicated after that.
At least 17 of elected justice, how you said, it was filed on 8th.
This was done later on. Then why haven't you informed? The interim order was extended. Did you inform? Not vigilant means there must be reasons why. No, the problem arises there. You can go and get a bail out there from Jharkhand, but you can't go and file a writ petition of the or 482 there. I don't understand why. Because Mr. Bhattakur, if 15/12 is not the document, then it will show that your case is a vindictive case. And as such, this court is quashed. But if 15/12 is a document which is there on records, then this court is going to dismiss the petition with cost. List the matter. Upon hearing the learned counsel for the parties, and the specific stand being taken in the affidavit in opposition filed to the affidavit in additional affidavit in opposition filed by the petitioner against the affidavit in additional affidavit of the respondent number 4. The moot question which arises is as to whether the petitioner, whether the respondent number 4, whether the document enclosed to the additional affidavit that is the communication that is the communication to the police station in charge, city police station, Bokaro City, Bokaro, Jharkhand, dated 15/12/2015, is a part of the FIR which have been registered as Bokaro City Police Station case number 08/16 under section 406/420 of the Indian Penal Code corresponding to GR case number 633/2016. This aspect would require certain verification to be carried out. Under this aspect can be ascertained by calling for the scan copy of the charge sheet. I think there it will be there now. Scan copy of the case diary of the charge sheet. Number 73/2023, dated 8/4/2023. It appears that the said charge sheet was filed before the JMFC Bokaro. And the said proceedings, and on the basis of the said charge sheet, the proceedings, the trial has commenced. Trial has commenced, no? The cognizance have been taken, and the trial has commenced. And the trial has commenced. Under such circumstances, the registry of this court is directed to call for the case, the scan copy of the case records pertaining to GR case number 44/16 in connection with charge sheet number 73/2023 pending before the court of the JMFC Bokaro. It is made clear that this court has not stayed the said proceedings before the said court. The petitioner, the response number 4 is further also directed to produce the certified copy of the communication dated 15/12/2015, which, as per the respondent number 4, forms a part of the FIR. There is no stay to the proceedings. I'll make it clear.
Point number 2 and 4 has not yet finally received. Okay, records are also not.
That's the nullity. The transfer.
Yes, that's all.
Who is appearing for the? Are these the private respondents here?
Yes, SN Nath was appearing, madam.
Huh?
Mr. SN Nath was appearing.
Mr. SN Nath. You are appearing. Who is appearing for them? 5 to 13. Crazy. Some wonder, don't you think that when the authority concerned or the judicial magistrate first class didn't have the authority to transfer, the transferring of the Palasbuli police station case to Nongpur and the investigations so carried out therein and the charge sheet so submitted all becomes a nullity. So now whatever has happened has gone useless. So the police should investigate this aspect and submit a charge sheet here. He couldn't have done that.
Yes. Who has given the application to this? What is the order was filed?
That is very serious.
Or my.
No, that order is not, it has been only mentioned here. I could see there's an SP's communication which he could get it from the RTI, na?
Yes, ma'am.
If I remember.
Who paid for that's what I mean. Who paid?
He only came to learn when it was,
860, my friend.
status report. With reference to the subject cited above, I am to inform you that the place of occurrence of the case falls under Nongpu police station. So the case was transferred by to Nongpu as ordered by the Honorable Judicial Magistrate First Class Amin Gao. There is no mention of which case, what records,
What
nothing.
taken, who has filed application and.
Mr. Talukdar, you are appearing for the SP. You get this information.
Information, I'm told that, I have received the instruction.
Hmm.
It has been sent directly to the Ministry of this.
Huh?
Ministry of the.
Receive this.
Scan copy of the.
Acquisition of the scan copy. Register General.
Okay, 61, my friend. It is one date is mentioned, order date 6740, 61.
Wait. Hey, yet you have record actually. From so Register General High Court of Meghalaya to the distributor received from the Register General. Huh? Yet here. Acquisition for demand. This is given by order to Register General. He did it. This is the records. Record to actually. Scan copy of the GR has not been received by the section till date. However, letter has been received from the register and the same is kept on record in flag T. Where you can use. Now, here, there is one letter from the Chief Judicial to the Deputy Registrar so and so WPC on. I am enclosing here with the scan copy of the GR in CD. What CD upon us? CD code location. So I'm enclosing here with a scan copy of the in CD. CD. Now that is one thing. But Mr. Talukar, tell me one thing here. Kindly see here at page 65. 60, page 60. The superintendent of police Kamrup Amingam writes that at the instance of an order passed by judicial magistrate first class Kamrup Amingam, the records were sent to Nongpur. So he will be knowing it. Yes.
Superintendent of police says whether all the records are transmitted.
Understood. On what basis? He says that he must have done it on the basis of an order passed by a court. Now that court must have, that order is nowhere there.
I have 2 dates, no order.
No, there is no order. Because this is a very serious issue. If there is no order, it is another big thing. And if there is an order, then it is another thing. The High Court will take its own course. But if there is no order, at whose instance also, was there anything to do with the police? The police may have done it. So you, at the time when you are transferring, you will have a record. You can't say that you have not maintained any record and send everything. The record of transfer has to be kept on, there has to be a file maintained for that.
The order sheet of the legislator Nongpur, my lord, says that the records, my lord, has been transferred. Page 91. Page 91, my lord. Here put up to the record meeting on being endorsed with police papers by the Honorable District and Session Judge Nongpur. Seen and produced the original FIR filed by Sri Manjulam Das, and the same has been seen by the magistrate there on 7/5/14. And the same is now forwarded by OC Nongpur PS Inspector so in connection with Nongpur PS case number so as PO for under River District. Also seen the case record transferred from the Honorable Court of CJM Kamrup Amingam to this court.
So that is why I was asking for the records. It say that the CGM has sent some, the record shows that the CGM has sent some CD of the GR case in the CD. So we'll do one thing, let us have it next Tuesday, on which date I ask this whether there is any CD out there, and you get your information. That is the only way of. Because if there is nothing, because there is a mention that there is an order passed. Because there in that order also it has been recorded that the CGM Kamrup has passed an order. So there will be some order. And you have to maintain some record. I don't think that the entire file will be, any file also has to be sent, you have to maintain this record. Pursuant to the order passed by this court on 9/8/2023, it reveals that the Registrar General of this court had issued a communication to the Registrar General ইয়াতে কাগজখন ক'ত গ'ল আপুনি? আমাৰ এখন ইছ্যু কৰিছো। The Register Judicial of this court had issued a communication to the Register General of the High Court of Meghalaya on 23/8/2023 with a request to direct the Chief Judicial Magistrate Nongpu to furnish the scanned copy of the GR case number 342/2014 to the registry of this court as registry of this court. It further appears from the records that the Registrar General of the High Court of Meghalaya on the same date had issued a communication to the District and Session Judge Ribhoi District requisitioning the scanned copy of the GR case number 342/2014. The record further shows that the Chief Judicial Magistrate Ribhoi District, Nongpu, by the communication dated 30/8/2023, issued to the Deputy Registrar Guwahati High Court, have mentioned that the scanned copy of the GR case number 342/2014 is enclosed in a CD. However, the record does not show from going to the records, nothing is apparent. It is not, the said CD is not found. Under such circumstances, the registry, this court also finds it relevant to mention that in the office note dated 11/9/2023, it has been mentioned that a scanned copy of the GR case number 342/2014 from the court of the Chief Judicial Magistrate Nongpu have not been received by the section. Let this matter be again listed on (28/9/2023). On the same date, the registry shall verify as to whether the CD has been sent by the Chief Judicial Magistrate Ribhoi District, Nongpu, as mentioned in the communication dated 30/9/2023, which is a part of the records. If the same is not available in the records, the Register Judicial of this court is directed to pursue the matter so that the scanned copy of the GR case number 342/2014 is available on the next date fixed. This court further, taking note of that the case was transferred on the basis of some order passed by the judicial magistrate, as can be seen from the communication dated 29/3/2019 issued by the Superintendent of Police, Kamrup Aminga, directs the Superintendent of Police, Kamrup Aminga, to bring on record the said order of the Judicial Magistrate First Class at whose instance the said proceedings, the said Wolosbury PS case number 183/2014 was transferred to Nongpu Police Station on 25/11/2014. List accordingly. Oh, itu untuk
Supplementary is agreement 19 to 22 total is for hearing.
Yes, Mr. Ahmed, your matter. Mr. Kyle, you wait for some time, you take it. Yes, anything you found out? Have you found out anything which may help you?
Yes.
Huh? Yes. Yes, why is it misconceived? Hmm.
They are referring to earlier period of March, January and March.
Show me.
Yeah, if you look at
Paragraph 3 of the petition. Yes. Challenge the respondent not delivering the code to the petitioner who were successful bidders in the e-auction of 12/3/2013 and 28/6/2013, in spite of the fact the petitioner had paid the full charge in advance, including taxes, levies, so and so, and yeah, the money deposited was retained by the Imam and more than Imam, and thereafter returned by the respondents on the plea that the validity had expired, and since the coal sold to the bidder could not be extracted, made available for dispatch to the petitioner during the validity period of 45 days from the date of sale, the money is being refunded and the auction sale shall be treated as lapse. Okay, then
in March 2013, that option was over. Every option is one time. It cannot be reopened later. Now, 3 months later, they come along and challenge it along with the subsequent. Which they were not successful. The June, they were not successful.
June.
It is an immediate question, they were refunded them. And along with the petitioner, there were other petitioners. Of whom they had sought for adjustment of the money that was remaining with us.
Who? The petitioners.
Along with the petitioner,
We are having 4 petitioners.
Oh.
Yes. Who have sought for money?
but were dealing with intake private limited. And money and the trade. They wrote to us saying that this is more or less given to us in a lot of just the money will be next one.
Who said? The petitioner number 2 and 4.
This is the from Malaysia.
Page?
The rate will not be loaded. They load that money will be adjusted against the next load.
This is only for one petitioner. What about the others?
Other than this, I do two documents.
Huh?
Documents,
There's no documents?
as far as the other issues are concerned.
What do you say?
It will be the.
No, you kindly come to page 37, page KK Minerals is the party.
No, not a.
KK Minerals is not a party. Anmol, JK Fuels, not a party. Anmol,
Subsequently, they again participated.
KK Minerals is not a party.
They have given it, but it's going down. That means that is keeping minerals. We have to confirm the existence of all the terms and conditions of the offer and then
Page
that page 37.
37. Yes. This is written by KK Minerals. Who is KK Minerals?
There's a lot of it bidders.
So he has nothing to do. Okay.
They all accepted the terms and conditions, that is the E of policy. Each and every,
Now, why are these documents of KK Minerals enclosed, madam?
you know, but
That page number 18 of the executive that has been shown to my lord. That is of January 2000, January, February 2013. It has got nothing to do with the auction that is involved. My whole issue has arisen out of the auction held on 20th June 2013. So that answers to my page 18 after my then certificate is concerned. Now, why taking minutes has papers have been added, my lord? This I'm trying to show that because they have monopoly in the trade, this is what has been a continuous kind of practice that they make people participate in the auction, make people pay the money, and then after money is they do not get the whole and they need this money for the long time.
Okay, now you, now you have paid the money. And after a period you will return the money.
After
When?
that, even after I was not taken the money.
No, here you were saying the money deposited was retained by the respondents and moved and thereafter returned to by the respondents on the plea of the paragraph 3. You say that. No, paragraph 3.
Yes, of March 2013. This is to show that this was a practice since last.
No. Kindly come to the last 7 lines. The money deposited by the petition.
That was retained by the respondents for 60 days and more, and was thereafter returned by the respondents of the plea that the validity period has expired. And since the sole cause of the petitions could not be extracted, made available for dispatch of the petition during the period of 45 days from the date of sale. And the money is being refunded and the option sale being treated as flat. Thereafter, I say, my lord, in paragraph, in paragraph 9, there's another precedent, page 9 and paragraph 9. There's another precedent above, the respondent number 1 notified option notified notice dated 20th June 2013. Pursuant to the petition number 1, along with others, participated in the auction in accordance with the terms and conditions. As required, the petitioner are all registered with the service provider. The petitioner was number 1 deposited the EMD as stipulated and participated in the said auction and was declared to be a successful buyer and was paid the serial number 5. Which fact will be evident on the computer generated list. Consequently, the respondent number 1 issued a sale intimation letter confirming the sale of 2,715 metric ton of the grade so. The sale intimation letter also indicated that the value be deposited within 7 days from the date of closure of auction and which copy is annexed. Now, in subsequent number 10, that the petitioner accordingly, the petition number 1 paid the total value including all of the applicable charges, costs, and paid the total sum of rupees 2,16,000. The petitioner intimated the satisfied by his letter dated 6 July 2013. I skip this and then I come to paragraph 23 at page 17. We have already argued. Paragraph 23 and page 17. If the humble petitioner states that in spite of the failure to arrange the stipulated quantity of both the petitioners number 1 and 2, petition number 1 and 2 are the successful buyers and are still retaining the money of the 3 buyers amounting to 75.5 crores approximately. In the meantime, I have notified yet another auction sale by notice dated to enter. And that is when I came immediately rushing to the conference call.
But you got the money.
I got it was not really got the money. They adjusted with the money with some other auction sale.
When did the auction sale happen then? How could the auction sale be adjusted unless you give it, you say so?
My lord, even if I take it, that the money was adjusted to some other auction sale, which fact is not before this one, but I still say
No, but you say that the money was returned. No, you say that paragraph number 3, it is returned. No, there are 2 things. One is 28.6 also. When did you get the money? No, because then we'll presume it.
In paragraph 13.
Hmm?
In paragraph 32, May not arise here. It's a bacteria that's why we not giving me the what you want. It's not possible of the option like that.
Now, did you get an interim order?
Without affecting my rights, without restricting my rights, they will proceed with the option C. And therefore, my rights, so far as the petition is concerned, it stands, so far as the previous option is concerned. It may not permit them just because a kind of a draconian kind of attitude and operation they do, madam, to retain people's money, and it's fully evil, madam. Are very categorically stated.
No, here the details which are, and why are you bringing the other three petitioners here? So they want to give you support, moral support. Because you filed it on 3rd of September, this petition.
Yes.
And you got the refund on the first refund on 21/5/2023. And the second is on 30/8/2013. You deposited on 6/7/2015.
November 2013, before we come up to this. You find that November 2013. I don't know. It is filed in November 2013 about this. We know what is sports matter, madam, more better than me, I do. What is sports matter? If you cannot supply, that is not sports matter. There was a riot, there was a disaster, I understand sports matter. That is what is getting the whole of the, they have no way. But that will not absorb them. That will not absorb them, even if they are paid. It is not absorb them from the obligations. Law can whatever they are trying.
So other three is in moral support.
Also, why did
No, they were never a part of it.
Somewhere there has to be something minor. It's not question of money, whether I will get some money or I will get some interest or not. It has to be somewhere something minor. They cannot go on this.
Then, Mr. Amjad Ahmed, so you tell me one thing, if that is so, how can you have condition number 4, which stipulates that they are to satisfy with the code, and later on they can't say anything about the code?
They are not there that it could happen.
Now, if that is the condition out there, then how can you impose upon them, say to them that there is no coal? Understood? No, But that is not the term of your conditions. Here, the conditions stipulates categorically 4.2. Before participating in the e-auction, bidders are to satisfy with the quality of the coal being offered from a source. So you are saying only as regards the quality of grade 1. So they can inspect. Hmm? No, that is only the quality of grade 1. But if it is grade 2, grade 3, I remember that.
Exactly, this is what I was trying to make, that you have price is higher, you don't give it to me and you are saying
So they are then they come to 11.7. Quantity mentioned in a notice are only indicative and may undergo a change depending on the factors like actual production of coal, bottlenecks in coal transportation, etc. Yes. Then there is the other one, the other thing, the other clause which they are saying they cannot oppose. Here, where is it? In case the balance quantity of unlifted quantity after the expiry of the validity period for supply shall be refunded subject to forfeiture of the EMT. Madam, on the last occasion you showed me one clause now, which was the other one? They were relying upon one clause to say that no, you cannot now say that the EI is bad, the quality is bad.
that was in the other case.
Yes, where is that?
That is, it does not really cover up 3.3.
Huh?
3.3.
3.0 should satisfy themselves about the rate feed destination from the no, as regards the quality. Later on they can't, because in that case, if I remember, you say your case was that initially they said grade 1, but they gave us grade 3.
Yes.
Where's the clause?
That is 4.2.
4.2, I've seen it. There's another clause. No, there was another clause. Has failed to offer full or part of the within the value in such period, no forfeiture. Now, what do you say about 11.9? You.
The cancel is you cancel the whole sale.
Is it so? Can be a part sale.
It cannot be a part because for them it is a holistic process they start. It's a holistic process they start. They go by the serial number and they cannot part. And this is not the case also. And this is not the case also.
No, they base their case on a particular thing, no? on the question of production also.
You have not illegal. You have to ask for this. Now they are saying that it's not.
Daily state, overload and fund, or in
It doesn't say so. Currently, I.
11.9. And 4. And we don't go.
Yes, you are not executing right. That is what I'm saying. You are not executing right. And this is not very the use after 10 years. For whatever reason the lesson was cancelled and the exercise 11.9, that is not the case. Their case is,
No, their case is force majeure.
there was any earthquake, there was any riot, there was any militancy operation. Something that was not within their control. You cannot say that I could not deliver and I could not come with the file and reach the court. This is not force matter. Unless you say that, okay, there was some rally, there was some riot, and there was some, I don't want to say.
What about floods like yesterday? What about floods like yesterday?
Yes.
That is their case.
The paragraph you say that having tabled the very development of the constitution, I have understood the content to know.
Paragraph 12, welfare. Hearing complete judgment result. Let me think what can be given. Huh? Hmm.
There I said, they are saying that I said that this is a policy, I did not take it. And here you are saying that there is no material and paper. But that is you are taking an event to them are not giving me anything. So both situations they can verify. One might not may allow or less economic cost of the delivery and I thought both situations they cannot debit this petition and get something or not. But somewhere it has to be said they have to take some reasonable logical stand. They cannot take that even the PMT are not giving anything here. Even give me the even PMT and don't give me anything else. Instead of
We have not detected anything.
No, she is also not saying that anything is bad.
And that is why both the petitions were connected, but for some reason, because of the business of the court, the matter could not be heard together. Otherwise, both the petitions were kept together, that either one of them has to be allowed. Both cannot be rejected and both cannot be allowed. I knew about it also, and I made it clear to the respective parties also. I said there are two situations, only one can be allowed and one has to be rejected. It depends which. But both cannot be allowed and both cannot be rejected. This also I was clear at the time of filing.
34 of the.
Yes, Mr. Kyle, where is he?
92, 22.
For these matters, income tax.
Option may come to page 96.
Of which one?
The number 5437.
5437.
Same on the
Page 96. Yes.
I have found the statement of long-term capital gain.
Hmm.
Let's compare the amount with the notice for issue. Actually, page 120. 120 is the notice. Reason for issuing notice under section of notice.
Yes.
Here looks for the amount. The dates are not matching. Here 7 items are there. There is for 6. And amount is also different. Opportunity to see page 96 purchase cost. Only with regard to item number 1 and 2. The purchase cost is there, and then from in zero.
What?
Page 96.
Ah.
The column statement of long-term capital gain.
Hmm.
There, first name of the company, and second date of sale, sale price, transfer expenses, net sale, purchase date, purchase costs. Excellent is to see. There disclose purchase cost with respect to item number 1 and 2. Others losses there from 0.
Hmm?
There from 0.
Hmm.
No amount has been specified. Capital gain on the basis of sale.
So they have shown the purchase cost as 0
Yes.
in the splash M 3000, 35,000, 35,000, 28250 and 6750. So there they have shown the amount to be 0.
0.
Purchase cost.
Yes.
So if the purchase cost is shown as 0, then the long-term capital gains will be more.
Section 1038,
And if the purchase cost is shown,
then
will be less. And if the capital gain would be less, so the loss would be more, or the income tax would be more. So if they are, that means they are showing they are paying more to this income tax department. Are they showing that these are exemptions? So they are claiming exemption under 1038 of this amount of 5,78,000, 5 lakhs, 57 lakhs. So they have claimed let us see how they have worked out this one. Exemption under 1038, let us see, because the computation which is being done out here, they will show this exemption somewhere. Page 93, exemption, where?
Total gross income, reduction under funds of total income.
No, there it's okay, but they will show somewhere in this computation of total income. And they will show certain deductions to be made.
Page 95.
Income exempt under section, yeah. You see page 95 down below, number 3, 57,58,923 has been shown as exempted. Now, if the capital gains is less, then the exemption will be less. So this amount would not get deducted.
For the reason for issuing notice under section 140.
Capital gains per annexure 10 is demand. Total is so and so. Due date for filing of the return September 30th, so and so. Capital gain STT is per annexure so and so. So that is why for you, it comes to capital gains is 37 lakhs. So if it is 37 lakhs exemption, then 20 lakhs is comes out. So what is the benefit they get if it is exempted? Let us assume that it is exempted. So it is an exempted, but either it will be 37 lakhs exempted or 57 lakhs exempted. But whether in either 37 or 57, is it required to pay tax?
What happened? The event here, they use the cumulative comprehensive step. You cannot stand.
Understood. Those are understandable, but how is it? How does it make this any difference out there if it is exempted 37 lakhs or 57 lakhs? That is not to be taken into account, or have you taken into account while computing?
Taken into account also.
How is it? In fact, in their accounts, they will be having 20 lakhs more, which is exempt. Or otherwise it is less. Means otherwise they would have had 37 lakhs in their accounts. They may not require to pay, but on records it will be 20 lakhs more. Yeah. In these 4 items.
Yes.
So that is why. But why have you mentioned in the reasons? But as per the IT return of year relating to FY1, no income loss in respect of sale of shares have been disclosed. On the basis of the information received from the ITD penny stock, I have reasons to believe that income has escaped assessment. Why have you said that nothing has been shown? So let us see, means how they are showing their cash in hand then. Is this the entire, how can they say that this is the entire reports? Is this so small? The computation starts and finishes of. So their cash in hand will be somewhere. Hmm? Income from house property, so and so, self-occupied, so and so, income from business or profession, minus so and so, profit as per unit, minus so and so. So and so. Total gross income, 15,30,000. House loan, so and so. Total income, so and so, round up to so and so, exempt in tax, so and so, so and so. Salary as per annexes, so and so, details of exempt, so and so, etc. Current year loss, so and so, so and so, current year loss. No cash in hand.
This constitution is not very
Huh?
reflected in their total expenditure.
The balance sheet.
Yes. Balance sheet of profit and loss account.
No, your basic reason is that while showing out there the capital gains, or which is exempted, they have sent zero as purchase price. And thereby the capital gains have become more. And because of that, that has entered into their accounts. And this should have been reflected otherwise in the cash in hand. In the profit and loss account, it will be shown. This is sale of shares or mutual funds. Or shares, that is it was exempted.
Long-term gain. It is more.
Capital gains. If it is more than 1 year or 2 years, depending on it. So as per you, it should be 37 lakhs. It's shown 25 penny. Means there has been, the sale must have taken place. No, therefore, to get the capital gains, sale must have taken place. Otherwise, there cannot be a capital gain on shares because it keeps on fluctuating. So this is one point. The second point is as regards the judgment of the
Approval of JSC. Approval was taken.
approval of
When it comes to
was there.
first month. Online details for approval of JSC events provided.
Where is it? Where is the approval? Because if you want to get away with all these problems, here you have to show it, because here you say that the notice is being issued after obtaining the necessary satisfaction of the commissioner of justice. Yes. So have you put it on affidavit this aspect? Then if you have not put it on affidavit, now why you are saying, have you stated out here that the JCIT permission was taken? Have you mentioned? Just bringing one document wouldn't help him. Where do you mention? Most important thing you have not mentioned. Why? Why? Why I will not mention, and you are giving this? Today, 7 matters I have taken, all are happening because of this. You produce the records. wherein the online, here this, you are saying that the online request for approval for AI is submitted. As approval is granted, notice on the AI is generated. Now, who has given the approval?
Yes,
How do you know?
for online request for approval of for JSC.
Is submitted. Then it is not mentioned that as approval is granted. Who has granted? They are basically, your notice says commissioner, and commissioner cannot.
Commissioner cannot.
Then, so the records has to show that the JCI has given the approval. You have to produce the records. How much time? 4 weeks.
And then it was the report that it was Gerard Pastor,
Where did you get this document?
sent by online.
Well.
Pastor.
So they know where the file is. Otherwise, where would they've given you this document? Yeah? This file is. Yeah. So they know where the file is. Unless you have good intention of helping the petitioner. Then unnecessary, why should we trouble petitioner any further? The Learned Counsel appearing on behalf of the Standing Counsel appearing on behalf of the Income Tax Department have been partly heard. So, during the course of the hearing, the question as to whether the approval was granted by the JC, Joint Commissioner of Income Tax, was put to the Learned Standing Counsel for the Income Tax Department. During the course of the hearing, though he produced a document, to show that on 30/6/2016 itself, the approval was granted, but it is not discernible from the said document as to whether the approval was granted by the Commissioner of Income Tax or by the Joint Commissioner of Income Tax. Under such circumstances, this court fixes the matter again. Under such circumstances, the said query remained inconclusive. Accordingly, this court fixes the matter again on 5th of October 2023. On that date, the Learned Counsel appearing on behalf of the Standing Counsel appearing on behalf of the Income Tax Department shall produce the records pertaining to the reassessment proceedings so initiated against the petitioners in the instant batch of petitions. Yes, everybody is waiting. Yes, Mr. Roy, waiting till 5 o'clock. What is it? You must be having something very important matter. Huh? Okay, let us take up Mr. Roy's matter 11. He has been waiting for.
I was looking for item number 10.
Okay. Yours is that one, the marriage, which you helped, but could not help in the financial thing. Ah.
We have 3 minutes if you want to take the matter on 14 at 2 o'clock.
14th at 2 o'clock. 14, lot of matters are there.
Next week, no, only the week commencing from your approval excuse me, only from the week commencing from 18 to 22. That week I am not there. Others I will.
Let us have it on 28 at 2.
on top of this, all those characters.
Top of the list. I don't think. Yes, Mr. Roy. It's always a pleasure to hear Mr. Roy. Huh?
11 to 13.
Oh, you paid it?
Second number of the
Okay, good.
11 to 13. Item number 13 also I paid.
You paid. Oh, these matters.
Only one petition. There are two petitioners. They paid for one petition. The remaining one.
This is matter pertaining to which one?
We have to pay for.
Huh? Oh, the housing. Housing. Yeah.
The lordship may kindly fix the date. I have read this totally.
You have to produce the records. Huh?
I have the report, sir. But not the entire report.
Huh?
Not the entire report.
What is this? Not the entire record.
Report I have to file for them. I still like to.
No, the question is, do you have the relevant record?
I have it, madam. Still, I have also got the defect in the record. Because still,
For last 5 years.
So when can you be satisfied?
in the final, the other records are there.
After having the puja?
Okay, sir.
Only a decade has gone.
So he wants it before puja. When can you get the records? He fixed it long time. No, not on 5th. Third of October. Mr. S. Bora appearing on behalf of the GMC. Those submits that pursuant to the order dated 31/8/2023, the records have some records have been received by him, but the entire records is yet to be received. Accordingly, this court directs the matter to be listed on 3rd of October 2023 at 2 p.m.
I have read the totally at the
You have paid it?
Yes, and
2 p.m.
1500
On that date, Mr. S. Bora shall ensure that the entire records are received. This court also duly takes note of that the pursuant to the order passed by this court, the petitioners have duly paid the court. Yes, Mr. Dekha?
That was 16.
Yes, revenue. You are the main person. Asminta Seru. What is your stand? Today I have been having a diverse type of matters in the morning, all different matters, from railways to everything. He has issued for final statement passed in sealing case for setting aside there. That is a sealing case on the 7/6.
Now, the affidavit filed by the deputy secretary, that says, my lord, that report of the cycle officer and under section 7(3), it was done in a perfect manner. And my lord, the land was converted to survey land. Only that much, nothing beyond that. And then, my lord, in pursuance of an order passed by the honorable court, my lord, an additional affidavit was filed. The email record, my lord, the cycle officer's report. But in the additional affidavit also, nothing specific can be discernible from the cycle officer's report.
What are these reports? to do with a particular thing as regards the section 7 notification.
Yes,
Section 7, why have you challenged Mr. Adeka?
Section 7 was a lot of anomalies. What had happened
So the
was-
procedure has not been followed.
procedure has not been followed, Manoj. In fact, there are reports to suggest that section 7 notification was not even published. Now, we preferred an appeal under 7(6) because there's a provision where we can appeal to the state law. Now, when we filed the appeal, Manoj, they did not dispose it of. Therefore, we filed a revocation. Revocation directed them to dispose of that appeal under 7(6). Now, they disposed of the appeal under 7(6), holding that the appeal is barred by limitation because so many years have already passed. Now, limitation, your lordship is aware, would run from the date when the final statement is published. Now, thereafter, we made an inquiry that several reports which suggest that the final statement was never published.
Has it been published till now?
No, it has not been published.
Then what do you mean? Without the final statement on the 7, does it have any value?
but as far as what procedure like to see that efforts, these two affidavits,
No, no, only thing is whether the section 7 notification has been issued or not. Without that declaration, what is there to challenge? Nothing remains. You have to return that. Hey, conjunction or some fixation of land ceiling. In fact, that I wanted to allow the repetition, I think, around in the month of October 2022, isn't it? But the government was not aiding us. Government was delaying the matter by not filing affidavit this way or that way. That is why I issued rule and said that nothing is going to happen to you.
Yes, therefore, I have seen the affidavits here. I will not find out comment. It able to state by the. I think it's there in the affidavit. They have only in one, first affidavit, mother only the statement is made that the circle officer has done, deputy commissioner has done everything in accordance with law. And that it was enclosed.
Where is this land?
Well,
Where is this land?
not Guwahati. Jilla center in Mota, not Guwahati.
Econ. Some fixation of land ceiling, econ. Volume 2. It's 499. On the basis of the information given in the return on the section 5 above, which shall be verified, duly verified through some agency as may be decided by the government, or the information obtained by the collector under section 6, shall prepare a draft statement showing amongst the other particulars the total area of land held by such person, the specific plots selected for retention with them, and so on. So the draft shall be published in the office of the Imam, and a copy thereof shall be served on the person or persons concerned in the manner prescribed. Any objection received there. The draft statement shall then be made final in terms of final orders passed under the proceedings under subsection, under proceedings subsections. And the collector shall sign it and affix it. The next subsection with effect on the date of the meeting is signed by the collector. Now, whether the collector signed it?
Well, nothing is known. What happened was, we were under the impression that this was always a retainable portion. Now, 2009, we saw the Jamapurji integrated and known as Sarkari. We preferred a series of RTIs as to what was the proceeding all about. Then it transpired that my predecessor had already exercised his option to retain this particular portion.
Oh.
Thereafter, that was not considered, and in the fine they annexed the statement where the retainable portion was not shown, was not specified. And entire portion was shown to be acquired.
Now, that is the only document that we have, which was furnished to us by way of an RT.
Oh, Mr. Borduzari, unless you have passed the final order, where is the question of anything under this ceiling? That is the only thing.
Yes, that is the condition precedent. So therefore, my lord, I had made some research, my lord, is to see the
Call for the record of this ceiling case. That is the only thing.
That will have to be a-
Once we call for the records, then only the thing will improve. These affidavits which they have filed is bogus.
But then there are orders where they have, the additional chief secretary has already produced the record and has already said. But page 121 is your instruction takes up.
120.
This is part of that review order.
Yes. Although a copy of the statement is served upon the demand, the petitioner claimed that the filing was not served. There is no records in the LA proceeding to prove that a copy of there was published by the office of the DC, and there is also no to suggest that the final statement was served upon the stipulated. There is also no records or documents available in their proceeding that was ever served upon. Also, there is no records in the LA to suggest the particulars that come to know the decision in the land declared influence. Permitted insurance and ground as per the certificate issued by the who? What is discrimination comes in again?
Now, my lord, there is a land possession handover certificate shown. And where one of my predecessors is shown to have signed the possession letter, my lord. He died way back in 68.
Now what has happened now?
My lord, now the statement says.
In my opinion, it is justified and fitness to hold that the order of the collector in the order sheet of so and so and the final statement of the Iman are irregular, faulty and deficient due to non-fulfillment of the provisions of the Act. Accordingly, it may be directed to give a hearing to the petitioner to consider the objection petition filed by the. Now, after this, you have challenged this order.
No, after this again, the my lord, deputy secretary wrote that there are irregularities, but it is too late in the day. 155 days.
125. Where?
But additional chief secretary, but the second.
It's filed by so and so.
No, some irregular.
Rejected, it has become provisions of the law has been well analyzed in the same order. Though some irregularities are alleged to have been done in the order of the Iman by the Iman, and if they have the proof to be positive at any stage, does not carry any legal backing to your You, Mr. What is it? You produce that case records.
I will have to secure it from the office of the deputy commissioner.
Upon no, from whom? The government. Or what?
The office of the district commissioner, deputy commissioner.
Upon hearing the learned counsel for the parties, this court deems it proper that for a proper adjudication of the this court deems it proper that for an effective adjudication of the repetition, the records of LA case number 372/1996 or 1976 is required to be produced.
There were two sealing cases.
Sealing cases, one is for 384 of 1974.
No, this order shows only about that only.
That order was on the course of 374.
That order only says about that.
372 of 1976.
Yes, madam.
Only one case.
Because he has mentioned about two sealing cases.
When we prepared the RTR, we came to know that there were two sealing case numbers for some reason. But final orders appears to appear.
Himself produced the records of sealing case number 372/1976. And also. list the matter again on how much time? List the matter on 5th of October for 2023.
And they put a similar direction for a bill.
Never know. I may not sit then. Yeah.